Hi everyone. Today's topic will be on trade union and industrial relations process and also collective bargaining and collective agreement. First, we are going to look at the key terms in trade union and industrial relations process. Number one is collective bargaining. So collective bargaining is a method of determining terms of employment and regulating the employment relationship, which utilizes the process of negotiation between representatives of management and employees and results in an agreement which may be applied uniformly across a group of employees. Collective bargaining means negotiating with a view to the conclusion of a collective agreement. And then we have collective agreement. Collective agreement means an agreement in writing concluded between an employer or a trade union of employers on the one hand and a trade union of workmen on the other, relating to the terms and conditions of employment and work of workmen or concerning relations between such parties. Collective agreement laid down in detail the terms and conditions of employment of all employees in the firm where bargaining takes place. And then we have negotiation, which is the process whereby two or more parties work through their conflict or dispute with a view to coming to some agreement or settlement. Conciliation is a process where participants to a dispute, with the assistance of a third person or the conciliator, identify the issues in dispute, develop options, consider alternatives, and endeavor to reach an agreement. And then we have mediation, which is usually considered to be a process in which the participants, with the assistance of the dispute resolution practitioner, identify the disputed issues, develop options, considers alternatives, and endeavor to reach an agreement. Mediation is a process in which the parties to a dispute present arguments and evidence to a dispute resolution practitioner, who makes a determination. What is collective bargaining? So collective bargaining is a negotiation process to establish a collective agreement. It is a process of bargaining between trade union and employers on terms and conditions of employment. It is done for the purpose of securing a better and fair terms and conditions of employment. Collective bargaining is a great social intervention that has been formalized to resolve industrial conflict. It is a right which is or should be the prerogative of every worker in a democratic society. Collective bargaining is the best method of regulating the terms and conditions of employment. In Malaysia, there are certain conditions which is to be complied in performing collective bargaining. First, trade union must be registered under Trade Union Act 1959. And then trade union must be recognized by employers. Any parties may request for collective bargaining, but the invitation must be made in writing. Collective bargaining must start within 30 days from the date of acceptance. All of the conditions are under Industrial Relations Act 1967. In Malaysia, legal intervention is through statutory recognition and restrictions on certain coverage or issues. Collective bargaining is using legal framework which is under Section 13, Industrial Relations Act 1967. Collective bargaining may include provision for the training of employees, the annual review of wages, and a performance-based pay system. Collective bargaining must not include issues pertaining to the following: promotion, transfer, the appointment and termination as a result of redundancy or reorganization, assignment of duties and dismissal, and reinstatement of employee, which are considered to be the employer's prerogative. Collective bargaining development in Malaysia is considerably weak due to the absence of strong and effective unions. The use of compulsory adjudication of resolving disputes affects the institutions of collective bargaining in Malaysia. In Malaysia, there are certain conditions which is to be complied in performing collective bargaining. First, trade union must be registered under Trade Union Act 1959. and then trade union must be recognized by employers. Any parties may request for collective bargaining, but the invitation must be made in writing. Collective bargaining must start within 30 days from the date of acceptance. All of the conditions are under Industrial Relations Act 1967. As for the legislative framework, whether collective bargaining is to be made legally enforceable or not depends on the contents of the collective bargaining, the purpose of the collective bargaining, and the effect of strike activity. There are three distinct functions of collective bargaining. The first one is as market or economic. Collective bargaining can determine the preconditions for supply of labor. It is regarded as a formal contract. Grievance procedure conducted is to ensure compliance. Second is governmental. Collective bargaining is a political process to regulate or manage power and mutual dependency between the parties. Collective bargaining as a systematic way of rule-making process, which involves the management and union, the management, the executive, and the grievance process, which is the judicial process. Third is decision-making. It provides employees participation through union representation in determining policies and rules in the workplace. Collective bargaining limits the tendency of management or employers to act unilaterally. Collective bargaining can also be used in exercising of authority with consent or mutuality. It can also define areas where decisions are made jointly or with consent. What is the relationship between collective bargaining, power, and conflict? Each function is not mutually exclusive. Collective bargaining should not be solely used as a mechanism to exert pressure to management. Collective bargaining converts conflict into an acceptable and systematic method of rule-making. From the diagram, we can see that there are three contents of collective bargaining. Number one is substantive terms and conditions of employment, and then we have procedural rules and also working arrangement. For substantive terms and conditions of employment, it is a primary purpose of union's existence and also the economic relations between parties, for example, wages, hours, holidays, etc. It should not be less favorable than the prevailing laws, for example, the minimum wage law and also annual leave. As for the procedural rules, it is a regulation of managerial relations, which is a regulatory framework for managing conflict or tension in the employment relationship. The procedural rules defines the what, how, and who of issues, which is to be resolved jointly. For example, the management and trade union negotiate to establish procedures relating to the recognition of trade union, grievances, disciplinary, and also redundancy. Next is the working arrangements, which defines the nature of work and how it is to be carried out by employees. It is primarily applicable to collective bargaining for in-house union. Negotiation will involve developing new work arrangements to improve productivity, assist in the adaptation of new technology, and to organize flexible working arrangements. It exists concurrently with other working arrangements, including standard operating procedures and job descriptions. We have two main components in collective bargaining relationship models. The first one is the conjunctive bargaining, which requires the achievement of some form of agreement to maintain the employment relationship and organizational operations. The parties agree to the negotiated terms as a result of mutual cohesion and settled their disputes because of their dependence on each other. The use of threat and cohesion is common. Results or agreement depend on the relative bargaining power between parties. Minimum cooperation needed equals maximum desired cooperation, and distributive bargaining, one side's gain is the other side's loss. Next is the cooperative bargaining. Collective bargaining will not proceed unless both win. Willingness to make concession to achieve negotiation objectives. It is not necessarily aims for single common interest, for example, improving productivity. Commonality of perception and greater acceptance of resolution is called integrative bargaining in cooperative bargaining. Disclosure of information refers to the transfer of management information, example planning, controlling and decision making, to union or employees' representatives. Unequal access of information is more prevalent in an employment relationship. Information is a source of power. For example, the information on profit, operation costs, and also the budget of a certain organization. If we look at the table, if the degree of information disclosure is low and the management's bargaining power against trade union is high, there can be no bargaining in the organization because trade union has no information and they won't be allowed to bargain anyways. If the degree of information disclosure is low, but the management's bargaining power against trade union is relatively equal, then there will be some form of coercion to accept the management's decision. But if the degree of information disclosure is high and the management bargaining power against trade union is also high, we will see frustration or alienation among the trade unions because they knew the information but unable to do anything about it. If the degree of information disclosure is high and the management's bargaining power against trade union is relatively equal, then it is an integrative situation whereby the management and the trade union will jointly solve problems. The disclosure of information is actually very important because it emphasizes on linking pay with productivity, performance, and working arrangements. It helps in the development of management strategies to secure employees' commitment, and it can reduce pressure from external sources as it is a social responsibility. For example, in the United Kingdom, it is a legal requirement for the disclosure of information in the Employment Protection Act 1975. For Australia, good faith bargaining requires disclosing of relevant information other than confidential or commercially sensitive information in a timely manner under Fair Work Act 2009. In New Zealand, providing information on bargaining for collective agreement is under Employment Relations Act 2000. But in Malaysia, there is no such provision yet under the Industrial Relations Act 1967. Other than having collective bargaining, we can also have joint consultation, which is the discussion between management and workers on matters of joint concern, which are not the subject of negotiations with trade unions, leading to advice to management but leaving free management's rights and responsibility to make the final decision and seeking to enlist the cooperation of all employees in the efficient operation of the company and the implementation of management decisions. Joint Consultative Council, JCC, is a mechanism for managers and employee representatives to meet on a regular basis in order to exchange views, to utilize members' knowledge and expertise, and to deal with matters of common interest which are not the subject of collective bargaining. As far as practicable, every establishment or undertakings should have a recognized machinery for consultation through the establishment of works committee comprising of employers and employees representative at floor level. From the table, we can see the differences between JCC and also collective bargaining. For joint consultation, it is not meant to extend employees' influence in the workplace, but collective bargaining meant to exert employees' influence collectively through representation. JCC covers issues or subject matter mainly involved operational needs and problems or implementation procedures and employees' commitment, whereby collective bargaining covers issues which include substantive terms and conditions of employment, for example, wage increase. In JCC, management determine the issues to be discussed, but collective bargaining, either party can propose issues to be discussed. Usually, union will start the issue. And then for JCC, management retains the discretion to make decisions and determine the outcome. But collective bargaining, decision outcome is subject to agreement consent from both parties. For JCC, management is not subjected to consent from the employees or their representative, and it is highly depend on management goodwill. But collective bargaining, it is highly depend on negotiation power and unity. For JCC, management prerogative is highly maintained, but in collective bargaining, there is erosion of management prerogative. There are two structures of collective bargaining. Number one is the national multi-employer bargaining. It is national industry sectoral bargaining, refers to multi-employer agreement negotiated between national or regional trade union and employers association. It is a feature of bargain or state corporatist IR system, which practiced by Scandinavian countries, Netherlands, Singapore, and even Malaysia. Bargaining is subjected to threshold or benchmark set by a tripartite mechanism. For example, NWCC set the floor wage as a threshold for collective bargaining. It covers only members or employers within the organization and may be extended to other employers, either voluntary or compulsory. The compulsory extension would require a legal provision in the IR legislations of each country. And then we have the single employer organizational bargaining, which is the bargaining at the organizational or enterprise level. The result or the agreement would only enforceable at the organizational or enterprise level. It may be extended to employees who are not members of union, depend on the IR legislation of each country. It is a prominent feature in the United States and Japan, including Malaysia IR system. It is suitable for countries with large geographical or territorial, such as the United States. The advantage of having national multi-employer bargaining is the application of common rule or standardization. It reinforces right for the job based on the nature of work rather than financial performance, and it prevents wage competition and promotes solidarity or unity among unions or employer. National multi-employer bargaining also prevents unfair competition and reduces trade union influence at the enterprise level. But the disadvantage of national multi-employer bargaining is it may be difficult to enforce and it conflicts with enterprise characteristics. As for the single employer organizational bargaining, the advantages are it encourages the creation of positive approach to IR. An agreement is internalized and suits the organization's characteristic or capability, and it is easy to implement and enforce because it is internal control and commitment. But the disadvantages are it can create rivalry between different bargaining units within the organization, which can cause fragmentation, and it may be used as a strategy or advantage by other trade unions to justify their claim. The procedure for collective bargaining in Malaysia is under the Industrial Relations Act 1967, which starts with the invitation by either party, either the trade union or the employer. An invitation to be made in writing and to include matters to be discussed, among others, training to enhance skills and knowledge, annual review of the wage system, and performance-based remuneration system. Trade union in Malaysia is prohibited under the law to include in its proposal for a collective agreement the following matters: promotion, transfer, employment, termination due to redundancy or reorganization, dismissal and reinstatement, assignment or allocation of duties or tasks. Trade union can, however, raise general issues relating to the procedures for promotion. Response in writing must be given within 14 days indicating whether the invitation is accepted or rejected. Collective bargaining must commence within 30 days from the date of acceptance. At this point, any party can take industrial action, for example, strike, lockout, and so on. If invitation had been refused, or 14 days had lapsed with no response, or collective bargaining had failed to start within 30 days, file a complaint to the Director General of IR. If at this point collective bargaining still failed to start, it becomes a trade dispute on matters raised in the proposal. from the initial invitation letter. Next is to complain to the minister within 1 month if employer, without reasonable excuse, refuse to discuss general matters pertaining to promotion. The minister's decision on this is final and conclusive if it has been brought to the minister. Thank you for watching and listening.